Yeah, I hate to tell you, but you're wrong about the Constitution. It's not your fault. I mean, that thing is like 7 pages long. Who has time to read that? And there's like 24 amendments. Pfft. But it's not your fault. Everyone is wrong about the Constitution. Think about this phrase, from each according to his ability to each according to his needs. In 1987, the Hearst Corporation conducted a survey to mark the bicentennial of the US Constitution. Over 50% of survey participants thought that that phrase, from each according to his ability to each according to his needs, was part of the US Constitution. And this wasn't a one-off result. According to a 2002 Columbia Law School study, nearly 2/3 of persons polled thought that this phrase came from the Constitution or from one of the founding fathers. But this phrase does not appear in the Constitution. James Madison, the author of the Constitution, didn't say it either. So, who did? Well, this was written by none other than Karl Marx in 1875 and then parodied by George Orwell in Animal Farm. Marx wasn't the first person to articulate this idea. Scholars trace the concept to the New Testament, which states in part, and distribution was made unto every man according as he had need. Now, the Soviet Union eventually incorporated the slogan into its Constitution as, quote, from each according to his ability to each according to his work, but that has never appeared in the US Constitution. So you can imagine if Americans confuse the US Constitution with the Soviet Constitution, they're probably wrong about a whole bunch of other things. Let's talk about it. One thing that people get wrong all the time is thinking that the Constitution mandates that English is the official language of the United States. That same 1987 Hearst survey found that 64% of the people believed that the Constitution made English the official national language of America. But English as the official language has never been part of the Constitution. Although English was the dominant language at the time the Constitution was ratified, many other languages flourished as well. The most common languages included Dutch, French, German, and the many languages spoken by Native Americans. Enslaved people spoke African languages as well as made their own English-based Creole languages. And most of the founding fathers favored bilingual education. Thomas Jefferson spoke English, French, Italian, Latin, and he could also read Greek and Spanish. He hoped that America would establish colleges that would teach in French, Spanish, German, and other languages. Others, like Ben Franklin, saw it differently and said things that were incredibly offensive and Malthusian, saying, quote, those Germans who come hither are generally the most ignorant, stupid sort of their own nation. They will soon outnumber us, that all the advantages we have will not, in my opinion, be able to preserve our language, and even our government will become precarious. Luckily, he didn't win the day on that one. Now, states with large German populations disagreed with Ben Franklin, at least initially. In the 1800s, Pennsylvania and Ohio passed laws allowing German to be taught in public schools. Of course, however, Americans have consistently attempted to limit the speaking of other languages in this country. Politicians have tried to introduce a constitutional amendment making English the official language, which would force the government to stop providing bilingual services. So far, these efforts have failed. And while a constitutional amendment hasn't passed, Congress historically has passed all kinds of laws that would prevent people from speaking non-English languages. For example, in the 19th century, the government forced Native American children to attend missionary schools. In 1887, the Bureau of Indian Affairs decided that mission schools on reservations were required to provide all instruction in English. Children who used their own languages were bullied and beaten by the instructors. This, of course, led to immense language loss. And, of course, French was the dominant language in the Louisiana Territory for over 100 years. The first Louisiana constitutions made English and French the official dual languages of the state. But Louisiana was a melting pot for different ethnic groups, and eventually their dialects merged to produce what we call Louisiana French. But in 1921, Louisiana adopted a new state constitution which reversed the policy of bilingual rights. The state banned the teaching of French in all public schools, which highlights one of the differences between the US federal constitution and individual state constitutions. But of course, these trends continue to this day. Representative Louis Gohmert introduced the English Language Unity Act of 2021, which would declare English as the, quote, official language of the United States to establish a uniform English language rule for naturalization and to avoid misconstructions of the English language texts of the laws of the United States pursuant to Congress's power to provide for the general welfare of the United States and to establish uniform rule of naturalization under Article 1, Section 8 of the Constitution. Of course, the reason that Gohmert wanted to pass this law is because it's not in the Constitution at all. And Gohmert's bill was referred to committee where it died. But putting language aside, surely that old chestnut, no taxation without representation, found its way into the Constitution, right? Well, the popular history of the American Revolution goes something like this. The colonists got so fed up with King George III's high taxes that they chucked British tea into the Boston Harbor, decided Americans would henceforth become coffee drinkers, and wrote a constitution ensuring that no one would ever be taxed again without being adequately represented. Well, as a resident of the District of Columbia, I would have to take issue with this particular summary of American history. In the 1700s, the colonists objected to the Stamp Act and other similar laws that imposed taxes on them because they couldn't vote and didn't have representation in Parliament. And in response, the English came up with a theory of virtual representation, which meant that since Parliament existed, every British subject was represented, regardless of whether they could vote. Of course, the young American colonists didn't exactly take to this early version of Zoom meetings. After all the pontificating about taxes and voting and the subsequent War of Independence, perhaps the biggest surprise of all is that the taxation without representation didn't make it into the final cut of the Constitution. Though the colonists did try hard to work it into the founding documents. The Articles of Confederation incorporated a we hate taxes stance by denying the federal government the right to levy taxes at all. This sounded cool on paper, but was a really big mess in reality because the new government couldn't pay its war debts. It also couldn't raise enough money for an army or navy. The British occupied forts in the Great Lakes while also dumping its convicts into the colonies. And so for this and many other reasons, the Americans had to write a new governing document that eventually became the Constitution. And you had better well believe that it gave the federal government the right to levy taxes. The problem is they forgot to mention that in order to levy taxes, everyone needed to be adequately represented. The state and local authorities also got the power to levy taxes, but the end result is that the Constitution doesn't guarantee no taxation without representation. But the motto is still a rallying cry for the disenfranchised populations, especially in the nation's capital where I live, Washington, D.C., which is also the only geographical entity in the contiguous United States whose citizens must pay taxes and register for selective service without having political representation in Congress. Well, at least political representation that can actually do something. DC residents pay more taxes than residents in 22 states and pay more money per capita to the federal government than any actual state. Now, we are not the only ones. Who else pays taxes without representation? Well, undocumented immigrants pay about $7 billion a year in taxes. Inmates pay taxes, and so do formerly incarcerated people, even if their voting rights have not been restored. American children work and pay sales tax and income tax, but they lack the representation of a vote. And that's just the tip of the iceberg. There's a whole bunch of taxation without representation in the United States. And that's probably because the Constitution doesn't guarantee that right. Americans hate taxes, but they love shopping, and a lot of people think that they have a right to enter a particular store, or at least they have a right to contract with other people, the freedom to contract. This guy believes he has a constitutional right to eat at the Trump Grill in New York City. But here the police officer contends that a reservation is not a constitutional right.
It's not a guarantee.
I can't revoke my reservation.
It's not a guarantee. It's not a constitutional right.
The protester is in fact wrong about his constitutional right to keep his dinner reservation, but this is an interesting question. Do people have a constitutional right to enter a store or a restaurant? The Constitution is often silent about most things, so it shouldn't be surprising that no one has an explicit reference to where people are allowed to be. But the 1980 US Supreme Court case Pruneyard Shopping Center versus Robbins said that the Constitution does not give people an absolute right to enter and remain on private property, even if they intend to exercise their First Amendment right to free expression. So if this man wants to get into a restaurant to protest, he doesn't actually have a constitutional right to do so, despite the First Amendment. But what about if the city or state government has imposed a vaccination requirement to enter? Does that violate the Constitution? Well, so far the answer is no, because not all unequal treatment violates federal or state laws. The Civil Rights Act of 1964 explicitly prohibits restaurants from refusing service to customers based on race, color, religion, or national origin. A restaurant can't refuse service to black people or white people or Muslims or atheists, for example, but when it comes to other classes of people, it's a complete toss-up. They can do what they want. Restaurants and business owners have argued that they have a religious right to refuse service to gay and transgender people because of the owner's religious beliefs. Now, the Supreme Court has yet to definitively settle that issue, and it's going to be very interesting to see what happens with the Supreme Court over the next few years on this particular issue. It's definitely going to come up. But when a local regulation prevents unvaccinated people from entering a restaurant, which is what happened with the situation in New York City, we're not talking about a protected or quasi-protected class of people based on their race, ethnicity, or gender. That means a lower standard of review, in other words, rational basis review, which basically no law ever fails. So the bottom line is that the Constitution is not going to protect your dinner reservation if there is a specific enforceable law that says you can't go inside. Then there is a phrase that I think everyone is familiar with, the idea that the criminal law presumes that you are innocent until proven guilty. Now, that idea that you are presumed innocent until proven guilty is one of the most significant principles in American law. The rights of criminal defendants are very much part of the Constitution. For example, the Fifth Amendment bars self-incrimination. Quote, "No person shall be compelled in any criminal case to be a witness against himself." This is known as the right to remain silent. The Sixth Amendment requires that people be given a speedy and impartial jury trial, an attorney in criminal prosecutions, and establishes defendants' right to confront adverse witnesses. And the 14th Amendment provides for due process of law. However, the Constitution does not require that a state prove that someone committed a crime beyond a reasonable doubt, and the Constitution doesn't say that you're innocent until proven guilty. Now, I'm not saying that the concept of innocent until proven guilty is not important, but the bigger point is that not all fundamental rights can be sourced directly to a line of text in the Constitution. Astute legal eagles probably already know that many of our important legal principles come from English common law. But the presumption of innocence has a more complicated origin story. It isn't found in any of the sources we traditionally cite for English common law, like the Magna Carta or the English Bill of Rights of 1689, or treatises by Coke and Blackstone. In fact, this presumption comes from Roman law and canon law, which form the common law of Europe. And eventually this principle made its way into common law in a very roundabout way. In Coffin versus the United States, the Supreme Court held that the presumption of innocence was a bedrock concept in the American criminal justice system. Then Justice White credited this to an Irish jurist named Leonard McNally. McNally was known as a zealous advocate for Irish defendants who were accused of treason. And during McNally's lifetime, the British system required 2 witnesses to prove someone guilty of treason, unless the accused was Irish, in which case 1 witness was sufficient. After McNally's death, the English press found out that despite his years of advocacy for the presumption of Irish innocence, McNally was, in fact, a double agent. He represented Irish revolutionaries in court, but reported on their activities to prosecutors for at least 26 years. Despite McNally's dubious role as a double agent for the government, today the principle of innocent until proven guilty is fundamental to the criminal justice system in the United States, despite it having no reference whatsoever in the Constitution itself. Now, that's just the tip of the iceberg of things that you're wrong about the Constitution, but this video isn't over because there's another LegalEagle video about even more things that you're wrong regarding the Constitution. Not you, obviously, but your friends, probably. Things like the filibuster and the separation of church and state. And this full-length companion video exists exclusively on Nebula because, sadly, if I put it on YouTube, it'd probably get demonetized and there's no way that you'd ever see it. But Nebula is different. As you probably heard by now, Nebula is home to tons of exclusive ad-free content like my first full-length documentary, Bad Law Words Good, exclusive videos on the legal rights that you definitely don't want to use, anti-SLAPP laws, and tons more. All of this exclusive content is only on Nebula, and you can get it for free with CuriosityStream. Of course, the reason all of these videos are exclusively available on Nebula is because they probably just wouldn't work on YouTube because of the way that the site works. On the other hand, Nebula is a different platform without an algorithm and without any ads, because Nebula is a place where we can experiment with content, put things on there that we just couldn't put on YouTube. It's where I put all of my videos ad-free and usually extended or with a completely exclusive companion video. I usually post my videos a day or 2 early as well. Nebula is creator-owned and operated, like with my friends Half as Interesting, Marquez Brownlee, Real Life Lore, Mike Boyd, and tons of others. There's new exclusive content released multiple times every day. And by the way, we've been developing Nebula like crazy. Nebula now has apps for iOS, Android, Apple TV, Roku, Fire TV, and Android TV. My fellow creators and I really care about Nebula, and we're thrilled to be partnering with CuriosityStream because they are the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crime, so if you like my videos, you'll love the stuff on CuriosityStream. And the best way to get access to Nebula and all of the incredible content is definitely through the amazing CuriosityStream Nebula bundle, with its current sales price of less than $15 per year to get full access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you're a CuriosityStream member. There just isn't a better deal in streaming where you get 2 streaming sites, both with content you'll actually watch and enjoy for less than $15 per year at the current sales price. But what's more, signing up will actually help countless independent educational creators beyond just LegalEagle. So sign up by clicking on the button that's right here on screen right now, which will take you directly to curiositystream.com/LegalEagle, or you can click on the link that's in the description. It's a great way to support educational content and get tons of exclusive content that you'll absolutely love. So click on this link that's on screen right now. Or you can click on this playlist with all of my other YouTube videos, so click here or I'll see you in court.